Hey everyone. If you are a business owner, you probably struggle a lot with trying to get business in the door, but on the other hand, trying to make sure that that business is not attached to a lot of liability. So I want to share some guiding principles that can help you decide whether a transaction is worth liability. And this is kind of where people talk, sometimes you'll hear that the sales department and the legal department, and sometimes if you're a small business owner, you may be having to make a decision for both of those departments, but sometimes they're at odds because sales says, hey, we want sales. And legal says, wait, be careful, there's all these, there's all these strings attached. So again, here are some guiding principles. The first place you want to look is a contract, because a contract is going to lay out all the terms and all the risks and rights and roles and duties of everybody. Now, the first red flag is if the other side doesn't want to enter into a written contract, or it says they don't need a written contract, or that this is just a gentleman's agreement, or we're going to do a handshake, you want to run away. Just don't do it. Don't do it. There's too many red flags about this, how these people do business. It's also, you don't know what your rights are. So it's probably just not worth it. And in fact, it may be a scam. So yeah, that's kind of the first bar. That's the first rule. The second thing to consider is what are the covenants that the other side is promising, and what are your covenants? So covenants are basically the promises that they are making, that the other side or that you are making. For example, if you buy a house, a covenant would be that that the seller of the house will make certain repairs before transferring the property from them to you. That's a covenant. So you want to make sure that your covenants are clear and that their covenants are. Another clause you should look for is the warranties or representations about the product or service. So consider that a warranty will be like if you have someone who, like a contractor, comes into your home and paints the wall. The warranty is that the paint will stay on the wall for at least 10 years. It won't start peeling. As long as maybe there are certain, as long as you don't, scrape it off the wall, for example. Or warranty is that a car will not break down within 5 years, for example. So that's a warranty and representation. It's something that will induce one party to enter into the transaction because it tends to speak to the quality of a product. Sometimes warranties are completely disclaimed. We give you no warranties. And then there's different types of warranties too. There's warranty for purpose versus warranty for a certain level of quality. And that's another topic, but those are some of the terms that you want to look to. And another term that's important are the liability. So what are your liabilities if there's ever a dispute or a breach, or if you can't fulfill the terms of the contract? Are you liable for everything that happens as a result, or is liability capped somewhere? Another clause that you want to look to are any conditions. So do certain rights apply only in certain circumstances, or do you have rights all the time? And that's important because you don't want to think, or perhaps based on a discussion, that you have certain rights, but then when you read the contract, it says, oh, you only get this if Y happens. So that's very important to know, to understand the relationship and potential risks. So these are very important to assess the risk of a transaction before entering into it, before you decide if this is really worth it. If you found this helpful, please like this video, subscribe to my page, and for more legal tips.